before I actually proceed any further, just in terms of housekeeping, if you have any technical issues, please do raise them in the chat function. And in addition, if you have any questions and questions, please do also raise them in the actual chat function, and we hope to look at them at the end of this presentation. In terms of background, I should just add that my background is that I used to be in private practice acting for tenants. Then I moved in-house and worked for a housing association, and now I'm in private practice acting for housing associations. Danny has a similar background in that he was in private practice acting for tenants and now is with Clarke Willmott acting for housing associations. So we have a wealth of experience from all perspectives effectively in dealing with housing management functions. And now moving forward, in terms of the structure of our presentation, we'll be broadly looking at these 5 elements. I will be looking at the law, and then Danny will be discussing current guidance and practical considerations. And then hopefully at the end of it, we'll be looking at experiences and Q&As and sharing some of our experiences. So without further ado, I'm going to move forward to our first slide. In preparing this slide, the one thing I always remember is that actually disrepair, although in reality isn't that simple, actually is quite simple if you break it down. And that's why I call it the anatomy of a disrepair claim. Essentially, there must be a property which a landlord is obliged to repair. That property has to have fallen into disrepair. The landlord has notice of the disrepair, and I've emphasized the word internal because there's no requirement for the tenant to put the landlord on notice if it's external. The law takes the general view that the landlord should be aware of the conditions of his housing stock. But taking the next step, once the landlord has been put on notice and does not carry out the disrepair within a reasonable period of time, then after that, the tenant has a claim for damages or compensation. So that's just to keep it simple, although as I said, in reality, it never works out that way, but it's just a reminder that it isn't that complicated. However, in that slide, I mentioned a number of things. The first thing was landlord's liability to repair. What we have to look at is where do those obligations arise from? I've highlighted the 2 key areas, which are express terms of the tenancy agreement and implied terms. I'll be looking at the express terms first. The starting point for all disrepair claims is to always look at the actual terms of your agreement with your tenant. The reason for that is highlighted by the case of Welsh and Greenwich LBC. In that case, the tenancy agreement said, maintain the dwelling in good condition and repair, and that was held to be wider than to repair. And as a consequence, the landlord was held liable for severe condemnation. Therefore, the starting point is to look at the terms of your tenancy agreement. Now, I've actually come across quite a few tenancy agreements where the phrase good repair is used, and my advice is that remove the word good whenever you get the opportunity to review your tenancy agreements. The reason is that the legislation, which I will address a little further down, mentions to keep in repair, and most tenants lawyers have attempted to suggest that the words good repair are wider than to simply keep in repair. And my view is, well, why give them the argument in the first place? And secondly, to date, it hasn't succeeded, but as I said before, why give them the opportunity? So my recommendation would be to remove the word good and simply say to keep in repair. Moving on to the next slide, the main source of obligations implied upon the landlord is the Landlord and Tenant Act 1985 and specifically Section 11. In this regard, I must emphasize one thing, which is that there are other acts that are also relevant. For example, the Defective Premises Act 1972. But I will be focusing on Section 11 because 99 out of 100 cases, Section 11 is the basis upon which we face claims against us in relation to disrepair. And Section 11 you will be familiar with. It's been in force for quite some time, and essentially it requires the landlord to keep a dwelling house in repair by reference to the structure and exterior, and keep in repair and proper working order the installations for the supply of water, gas, electricity and sanitation, and to keep in repair the proper working order the installations of space and water heating. This is all material we're probably quite familiar with, but it's always a good idea to recap on it. In terms of a dwelling house, well, Section 16B defines this as the building which is let to the tenant. This doesn't often arise as a problem, but in order to illustrate the point, I've set an example. It's not directly on point, but it just makes the issue about the dwelling house relevant, which is if, for example, you have two flats in a converted house and the ground floor flat suffers a leak from the roof, which will not form part of the structure and exterior of the ground floor flat. So technically, on that very limited reading, the dwelling house would only be the ground floor flat and would not have a cause of action against the landlord because it does not form part of the structure and exterior, in this case, the roof. There are other elements that would allow them to have a cause of action, but I just wanted to use that as an example to identify what a dwelling house was. The next element is to keep in repair. And there are a number of quotes that are very useful, and my favorite, to be honest, is the one by Denning Lord Justice, and he says that if the work which is done is the provision of something new for the benefit of the occupier, that is, properly speaking, an improvement. But if it is only the replacement of something already there, which has been dilapidated and worn out, then, albeit that it is a replacement by its modern equivalent, it comes within the category of repairs, not improvements. I have actually also added another quote, which states, "A state of disrepair, in my judgment, connotes a deterioration from some previous physical condition." I don't propose to go through the third one, but the main emphasis here is that there is something that has deteriorated from its original condition so as to be in disrepair. And essentially that is what you then have to keep in repair. The next element, and this is usually the area where there's most dispute, is the structure and exterior. Section 11 requires the landlord to keep in repair the structure and exterior of the dwelling. The list below is a non-exhaustive list, and for example includes walls, partition walls, roof, plaster, extractor fan, staircase and banisters, paths that lead up to the main entrance of the property, not necessarily, for example, garden path leading to the back, windows if they are a substantial and integral part of the wall. The next element in relation to Section 11 is the installations. Most of the time, these are installations that are within the tenant's dwelling, but please be minded to remember that a number of large developments or blocks of flats often have communal boilers, and they would be caught by Section 11(1)(a) B of the Landlord and Tenant Act 1985. Moving on to the next slide, what would be the standard of repair? The standard of repair is qualified in Section 11 as well. It goes on to state that regard must be had to the age, character and prospective life of the dwelling house and the locality in which it is situated. This hasn't arisen that often as far as my experience is concerned, but an interesting case here is Montoya and Hackney LBC, where the court overturned the finding that twisting of the doors and windows amounted to disrepair due to evidence from the single joint expert that the defects were commensurate with the age and type of property and therefore was not disrepair. It doesn't happen often, but it's just to have regard to the little details and have regard to the age and character of the property. In terms of the standard of repair, the point to remember is that the standard for social landlords is not higher than that for, say, the private sector. The other element, which is sometimes forgotten, is that landlords are entitled to carry out repairs in the least onerous way provided it is reasonable. Often, you have multiple options in terms of resolving a disrepair, in terms of the way you carry out the works. And it is the landlord's choice on how to carry out that work, as long as it's within a reasonable range of works that could be used to solve the problem. So the onus is on landlords, despite what, for example, tenants may say. Moving on to the next slide, under Section 11, it's been quite settled that the requirement to repair combines with the landlord's obligation to make good and redecorate upon completion of those works. The other element, which is often a problem, is that there's an implied term that if a landlord has to carry out work at a property, they should also have a right to access. This is usually applied by reference to the tenancy agreement, also available in common law, and also available under Section 11.6 of the Landlord and Tenant Act 1985. But I just want to come one moment back to the tenancy agreement. I mentioned earlier that the tenancy agreement is the first document you look at. It's also very useful in terms of, for example, access rights. Most modern tenancy agreements do have terms that provide for access. The only difference is, and it's very relevant, is that some tenancy agreements might suggest at least 48 hours notice, others might suggest at least 24 hours notice, and most also emphasize the manner in which you can contact the tenant, for example, a letter sent by first-class post. So in terms of access and evidencing access, your tenancy agreement is also very important in that regard and emphasizes the need that you should always have regard as a starting point to the terms of your tenancy agreement. Moving on to the next slide. Now, earlier I mentioned whether there had been changes to the law, and I put a question mark next to it. I think everybody will be familiar with Homes Fitness for Habitation Act 2018. It came into force last year. But moving on to the next slide, is it anything new? Well, the reality is it isn't. And the reason I say that is because the idea of something being deemed unfit for human habitation has been around for some time. For example, well, not for example, what I mean by this is that the idea of fitness for habitation was first raised in 1885 under the Housing of the Working Classes Act. And since then, it's either been reenacted or amended. But the reason we've only mentioned the Housing Repairs and Rent Act 1954 was that was the first occasion where the definition of what was unfit for human habitation was actually defined. And it did it by reference to 8 things that, if present, would make the property unfit for habitation. I'm not going to repeat them here. They're on the screen and on the slide, sorry. And the reason I'm not going to repeat them is because I'm going to mention the changes and then mention them in their whole grouping, so to speak. But there's 8 so far, and in the slide you will note there's a 9 and a 10. The reason I'm going to mention number 9 now is that Section 8 of the Landlord and Tenant Act 1985 added a 9th element, internal arrangement. So that can also be used to suggest the property is unfit for habitation. However, although that particular section has been on the statute book for some time, it was probably made redundant or obsolete, very, very quickly, because it only applied to properties where rent was less than £80 per annum in London and less than £52 per annum elsewhere. So it was never effectively used, and I don't recall ever a time when it was raised, but I came into law much later, so that's probably why. But it was redundant. Now, sadly, due to the events of Grenfell Tower, that necessitated a change in the law. Although one may think that tenants have considerable rights, Section 11, common law, and the various other acts that I've mentioned, for example, the Defective Premises Act, in the Grenfell Tower situation, the tenants didn't actually have a cause of action. And so the Karen-Buck bill was brought forward. In addition, there was a belief that the local authority enforcement under the Housing Health and Safety Rating System was probably not as effective as it had been hoped. So the end result was the Karen-Buck bill was brought forward and it came into force following the events in Grenfell Tower. I'm going to move swiftly forward to the next page to emphasize that effectively what it did was it revived the Landlord and Tenant Act 1985. It removed the rent limit, and in addition, it increased the list of defects to 10. any prescribed hazard that was the next entry. However, looking at Section 9A, which is now passed into law, it requires that the landlord it has an implied covenant that the landlord will maintain the dwelling in the sense that it is fit for human habitation at the time that it is granted, and that it will remain fit for human habitation during the term of the lease. The other element is that how do you go about establishing whether the dwelling is fit for human habitation? And in this regard, Section 10 defines what will be considered unfit for human habitation. So as I mentioned earlier, there's repair, there's stability, there's damp, natural lighting, ventilation, water supply, drainage and sanitary conveniences, facilities for storage of water, etc. 9 should say internal arrangements and prescribed hazards. If a tenant is able to establish one or more of these criteria, then it will establish that the property is not reasonably suitable for occupation and therefore is unfit for habitation. And so that's how the cases will now be progressing. Again, I've used a quote to help, and in this regard, I've gone for one from 1927, but it is actually quite helpful. And it emphasizes that if the state of repair of a house is such that by ordinary use, damage may naturally be caused to the occupier, either in respect of personal injury to life or limb or injury to health, then the house is not in all respects reasonably fit for human habitation. And this emphasizes the main difference between, for example, repair claims or disrepair claims and fitness for habitation claims, if I could call it that. Fitness for habitation developed from a public health perspective historically, and this quote reinforces that point. So what exactly is fit for human habitation? I'm going to move from this screen to the next one because I first want to emphasize in terms of when it came into force. The first thing to note is that the Act came into force on 20th March 2019, and it applied to all new residential tenancy agreements for less than 7 years and not to shared ownership properties. It also applied to fixed term tenancies entered into before that date, but then subsequently after 20th March 2019 became periodic tenancies. So only upon the expiry of the fixed term. And after 20th March 2020, all periodic tenancies were affected by the Act. So the majority of tenancies these days will now be covered by the Act, in England that is. The only, I suspect, example I can think of that would fall outside it is a fixed term tenancy that was perhaps granted for 5 years, let's say on 19th March 2019, and the fixed term has still not expired. So in terms of the Act to bite in relation to that particular tenancy, it's about 5 years away from the date it was granted. In terms of the implications of this new Act, the first thing to note is that it now allows tenants to use the HHSRS rules against landlords, so to speak. Although the tenant will not necessarily have the same remedies available, it at least now allows the tenant to take direct action. In terms of whether it will produce more disrepair claims, I'm not absolutely certain it will, simply because the way disrepair claims are now funded by virtue of the conditional fee agreements, there has been a substantial increase in disrepair claims in any event. It may widen the scope, but I think overall it won't be a huge increase just because of the current increase already. In terms of damages, I think that's where it will make a difference. And the reason it will make a difference there is because if a property is considered unfit for human habitation, then the suggestion is that it's not fit for occupation, which would then suggest that damages should be 100% of the rent. So, for example, in terms of calculating damages, I often use the rent reduction method, which is you have a look at what the condition of the property is and you reduce the rent by a percentage to suggest that this is how much it's affected the person who's lived at the property. But by referencing it's no longer fit for habitation, having that finding of fact made, that would suggest that it should be 100%, as in you can't live in it at all. In terms of improvements, in some ways, this area has not actually changed that much. And I use the example of a door in a house that is not in disrepair, but is, for example, not well designed and has a gap between the floor and the door itself, which allows in rain. Well, if there is no effect on the property in terms of disrepair, then replacing the door would be an improvement. But if, for an example, water starts coming in and starts damaging, say, the wall next to the door, then you would have a duty to actually replace the door, because something affected by it is falling into disrepair. So improvements, whether you have to do them, will depend on the particular circumstances. But in a nutshell, if the only way to repair something is to make an improvement, then that would be a way forward and you would have to do it. So the same would apply in relation to the Fitness for Human Habitation Act. In terms of litigation, we would say that the main area that is going to develop now is the argument around reasonably suitable for occupation. It will be turning on the facts of each case, but you will have already noted that the protocol has been amended to include the pre-action protocol for housing conditions and what used to be disrepair. So the wording is already changed. And although there's been a change in the law, there's not going to be a significant change in terms of the procedure. All that will happen is that you will now face pleaded cases where not only will Section 11 be quoted, but Section 4 of the DPA, for example, and common law rights, but also Section 9 and Section 10. In relation to the tracking, that will not change. They still have to establish, the tenants' lawyers, which category it falls within. And in terms of a counterclaim, tenants will be able to raise it as a counterclaim, for example, in rent-to-rear claims as a defense, or as a counterclaim to be more accurate. Moving on to the next slide, what it will mean is landlords will have to look at matters in a more holistic manner and look at the entire circumstances of the tenant's occupation of the property. There's a list of items here that would be affected, but the main, I think, emphasis here is that we already are dealing with a lot of tenant law firms that fund these matters under conditional fee agreements. That will probably increase a little bit because they've already increased substantially so far. Sorry, I'm just going to grab a bit of water. And in terms of the next slide, should we be worried? I want to emphasize 2 points here. First of all, as long as landlords maintain their properties and carry out works and improvements on a regular basis, that should prevent these claims being too successful. But the one point I really want to emphasize is accurate record keeping. That will, in my view, be your best defense. And I will illustrate that point in this way. Sometimes we get records that show a leak in bedroom 1, a leak in bedroom 2, and then, for example, a leak in bedroom 1. I'm going to use the example in terms of an 18-month period. So what one set of records shows is that bedroom 1 shows that a leak occurred from the roof and it was repaired within a reasonable period of time. And then the second entry shows that a leak occurred in bedroom 2 that related to the radiator, for example. And then a leak in bedroom 3, say 12 months later, shows that a leak occurred from the gutter. I should say bedroom 1 if I haven't. And sometimes what our records show is that a leak in bedroom, and without emphasizing which room, and without emphasizing the cause. And this is what allows tenants' lawyers to argue that, in fact, we had records of a leak from day 1. Whereas if our records identify as accurately as possible what the cause of the leak in each case was, then it allows us to defend a claim by saying, well, no, each item was different and each item was repaired within a reasonable period of time. So to my mind, accurate record keeping is the best way forward to deal with these claims. In terms of defenses, the main point I want to emphasize is item 1, unfitness for occupation that's caused by the tenant or a tenant's breach of a tenancy agreement. Landlord will not be responsible for that. Moving on to the next slide, there's also, for example, where carrying out works may cause a landlord to breach any other obligation. For example, planning permission. Again, a landlord will not be liable for that. Another category is, for example, any works or repairs that require the consent of a third party, for example, the freeholder, and that's not forthcoming. That would potentially be a defence as well. And this is over and above the usual defences that Danny will be dealing with. But moving on to the next slide, what can landlords do about this? Well, it's an opportunity to review your policies. Most of you are already doing this, to be honest. For example, when a property becomes void, you have a checklist at sign up and you take periodical checklists thereafter and take photographs. Accurate records, I've emphasized. Inventory and checking current stock regularly. Having improvement programs. And I've missed out adopt a cross-departmental approach because I wanted to deal with that last. And the reason I wanted to deal with that last is because I dealt with a case where we had the repairs records, but we also then got the housing officers, housing management records, and we had entries in there that said that the housing officer visited the tenant and asked about any other issues such as disrepair, and the tenant said no, there weren't any issues. And that record was absolutely brilliant for us because instead of a 2-year claim, we could say to them, well, we went to the property at least 3 times, I think it was, and on each occasion you did not report a disrepair, and therefore there was no disrepair, say 2 years ago, it was only 3 months. And so adopting a cross-departmental approach is part of the accurate record keeping of conditions in the property, and that, I think, will be the best way forward to defeat these claims. In terms of the disrepair claims, what I would like to emphasize, the most important thing is, I think, your best chance is to make sure that you keep accurate records because that will stand you in good stead in relation to dealing with these claims. In terms of the next part of this presentation, I'm now going to pass you over to my colleague, Danny. So if you just bear me 1 second, and I'll pass you over to Danny now.
Okay, great. I think I'm in business and can be heard loud and clear. Thanks very much for joining us this morning. Nice to see a few familiar names on the attendees list. I hope you found Muzz's outline and just quick recap on disrepair interesting. So what I'm going to do is just kind of develop that and put the old COVID-19 spin on it, and how all of this is playing out in the last sort of 2 or 3 months, and how it's probably going to play out in the next few months. Muz touched briefly on defences, which are basically reasons why a landlord could essentially escape or avoid liability for a disrepair claim. And I'm just going to concentrate specifically on 2 of them because I think they apply the most during COVID-19. So as you'll all be aware, one of the fundamental principles of any claim for disrepair brought by a tenant against you, you've got to be told about it. And of course, lots of tenancy agreements will say that the tenant must report disrepair to their landlord. Sometimes tenants will report it whilst your contractor is on site, and of course you've got no sort of close proximity to the contractor. It's an outside agency. If the tenant essentially mentions it to them that something else is wrong, then of course if they can prove that that's what happened, that can fix you with notice. It could also be a phone call about something else. So of course if a tenant rings up to check their arrears balance, for example, or make an inquiry about their rent, if they say, oh, by the way, I've got this leak under the kitchen sink, I need you to take a look, that's notice. Of course, it may not be recorded by your income team because it might be a different department, but if they can essentially show that they told someone at your organisation, then you're fixed with notice. And in a nutshell, all I want to say is that COVID-19 hasn't changed any of this as regards notice. So the tenant is still obliged to let you know of any issues. There's no sort of excuse, well, I didn't tell you because I was preoccupied or couldn't let anyone in or whatever. Things like access, that's a whole separate issue, but they still need to tell you about it. So do remember. And then the second notable defence for landlords is essentially the requirement for tenants to give you some time, reasonable time, to carry out repairs. So the classic example is the tenant will report something, and then 2 days later, before you've even booked an inspection or engaged contractors, you've got one of those awful letters before claim for disrepair in your in tray. So we're just going to go through some examples, and again, we'll look at how all of this applies in the time of COVID-19. So you look at the top of the slide there, how long you should deal, the period within which you should deal with a repair will depend on the actual defect. I think that's fairly obvious. So a common sense approach will need to be applied, and then if you've got any policies or guidelines that deal with this, then that will need to be adhered to. And then something to remind you all of is that investigative works count in terms of the landlord getting into action, as it were, to sort out the defect. So investigative works could be further inspections, further surveys, etc. So just looking at some examples of what would be an emergency repair, something that we'd say ought to be dealt with within hours, not days. So 1 to 3 days, it says there. That's probably should be expressed more as 24 hours to 72 hours. So of course we've got lack of heating and hot water, especially if you've got a vulnerable tenant. Leaks are emergencies, of course. They need to be dealt with, especially if they're uncontainable and can cause damage to the flat below or next door, etc. You've got moderate period for, let's say, vermin infestation. Often landlords engage contractors, pest control rather, to go in and have a look, and there's a baiting program. You have to lay some traps, etc. So we say about 10 days is appropriate, and then you've got sort of low scale periods for, let's say, mold growth or broken washer on a tap. They're just examples. So, of course, how is this all affected by COVID-19? Because clearly some of these emergency works that need to be done within 24 hours may not be done within 24 hours because of what's going on. So we're going to expand on that in a bit more detail. Here's just a quick recap of defences for landlords in terms of escaping liability for disrepair claims. So the top two I've already spoken about. They've got to tell you about it. So if you haven't had notice, that's a good defence. And if you haven't had enough time to sort of get your house in order and sort out the defect, then that's also one. But then you've got if access is refused or unreasonable conditions attached. So this, I say, could be quite relevant to the current scenario, because of course, if a tenant makes you do something completely unreasonable or silly, then you're not obliged to pursue access. What I mean by that, unreasonable conditions, for example, obviously this is prepared sort of pre-COVID, is a tenant might say, you have to pay me for my time. I want £200 an hour for you to access my property to carry out repairs. Or it could be, in theory, for example, a tenant who says, yes, you can come into my property, but I need you to wash your hands every 30 seconds. So that could be deemed as unreasonable. But the bottom line is landlords can avail themselves of defences if the tenant attaches any sort of unreasonable conditions on doing the work. You've got acts of neglect and waste, meaning it's not possible to gain access. So that classic example of that is hoarding. Of course, if you go to property to sort out a repair and you can't even get past the front door, then again, that should help you to avoid a liability. You can also escape liability where any defects are cosmetic only and consistent with the age and character of the premises. So we're talking about maybe some minor cracks or some paint fading. You've got some small defects there as well, nail holes or minor cracking. That shouldn't amount to disrepair. Design fault is on there as well. Now, this one's interesting, having regard to what Muzz talked about earlier, because of course we all know that if something's designed a particular way and then it causes some sort of issues at the property, it doesn't normally amount to disrepair. We can just shrug our shoulders and say, well, it's not broken, it was just built that way. But of course we have fitness for habitation, which we've all heard about now, and that may well kick this particular defence into long grass. So we'll wait and see. And the last two defences are very straightforward, which you'll all be familiar with. If it's a failure by the tenant to use the property in a tenant-like manner, of course that might mean failing to ventilate the property, resulting in mould. It might mean, damaging your own door, for example, etc. And then you've got, lastly, the tenants. You've got defects that are the tenant's responsibility. So I've actually seen tenants claim damages for defects that have resulted from their own construction. So, for example, a tenant on a case built their own conservatory, and of course they're now saying to the landlord, I want damages because my conservatory is broken. So there's just a quick recap of the defences. And just wanted to mention on the subject of COVID-19, I've put here negligence. No doubt we're all scared and terrified about, what if we go to a tenant's house and do a repair and give them COVID, or they give it to us. There's probably all sorts of issues between landlord and tenant, but probably internal issues within landlords, because of course, if you're employees, the employer has a duty to make sure you're safe. And the bottom line is, in theory, you could be negligent if you, pass on COVID, don't take any without taking any precautions. And just with reference to the top of the slide, you can't eliminate the risk. We've seen what this virus does and how it gets around. It's going to be very difficult to completely wipe out the risk of transmission, but you can certainly minimise it. And this is what it comes down to, that you can surely avoid any accusations of negligence or negligence claims if you take the right steps to just minimise the risk. So moving on to that, the government has very helpfully, or not helpfully, some may say, issued lots and lots of guidance about how we should be going about our business with tenant repairs. The three main ones that I want you to note and read, if you haven't already, are the first three. I apologise, I don't think there is a link that you can click on to take you to the guidance. But if you simply copy and paste any of those top three bullet points, or even just Google search them, they will come up. So it's essentially three bits of guidance. You've got working safely during coronavirus, brackets COVID-19. This guidance is essentially for everyone, everywhere. It's not landlord and tenant specific. It's basically applies to everyone. And in there are some tips and certain things you should do, which we'll touch on in more detail shortly. But that's your generalistic one, which you should all be familiar with. Then you have COVID-19 letter to social housing residents. This is a very specific one. It's a letter issued by the government. And although it's not so much guidance in the true sense, it does offer an insight into how landlords will be treated in the event of disputes, for example. And that's a short few-page document. And then you've got the third one, which is coronavirus guidance for landlord and tenants. And that is your specific guidance that applies to repairs. That's the one where the emphasis is on. So I'm just going to quickly tell you the relevant extracts from the guidance in case you don't have time to go off and read it all. But if you look halfway through the slide, these are actual quotes from the guidance. So it is in the best interest of both tenants and landlords to ensure that properties are kept in good repair and free from hazards. So that, to me, is a sensible middle ground. It applies to everybody. We're all in it together. Tenants should let their landlords know early if there is a problem, and landlords should take appropriate action. So no surprise there. Guidance just reaffirms that landlords essentially have to crack on with their obligations. And these three quotes are ones that I'm encouraged by, and perhaps you will be too, because it shows that the guidance does recognise the difficulties that landlords will have. And against this background of disrepair claims that you're all getting hit by, I think it's important to note this and take some comfort from it and rely on it when we need to. So we understand current restrictions may obstruct some routine and statutory inspections, but we expect landlords to make every effort to meet them. If resources remain stretched, we are recommending a pragmatic approach to enforcement from local authorities. So that seems to me just to be saying, look, we're going to give you guys, you landlords, a bit of leeway if you need it. This should mean that tenants who are living with serious hazards that a landlord has failed to remedy can still be assured of local authority support. Landlords should also know they should not be unfairly penalised where COVID-19 restrictions may have prevented them from meeting some routine obligations. So there's the nice one, the icing on the cake at the end there for all you to take some comfort from. And the guidance, the tone of the guidance generally is basically all work should now be done, because a few weeks ago we had guidance that suggested only the most serious and urgent work should be done. But the general gist of it now is everything should be done, you know, routine and emergency works, but with appropriate safeguards. There are, of course, still people shielding, and there will be, of course, tenants with symptoms of COVID-19. So the guidance for those people is repairs should be undertaken only when there is a risk to the tenant or household. Unfortunately, that's undefined. So essentially, it leaves landlords to apply common sense, basically. You know, if it's a small leak, perhaps, that isn't damaging the neighbouring property or causing any pools of water, then perhaps that can wait. However, if there was a serious leak in the flat above and the ceiling looks like it's about to collapse, then that's something that might justify some action when you've got a shielder or someone with symptoms. And then I just want to add here that all this guidance applies to gas safety inspections as well. Although gas safety inspections are beyond the scope of this webinar, we've certainly seen a lot of instructions from landlords for gas injunctions. They've struggled to get access over the last few months, and there's been issues with COVID-19, etc. So this guidance also applies to those scenarios too. I'm just going to go through some tips and suggestions with you all now. And again, this is just sort of drawn out of the guidance and perhaps a bit of, and also from a bit of experience we've had in advising landlords. Obviously, pretty straightforward one there at the start. Don't attend if anyone is showing symptoms. That's the guidance, but of course that will depend on the risk to that particular household. Big, massive one, and this is, I think Muz said it about 3 or 4 times as well, keep records. That cannot be underestimated, because it's the keeping of records where your disrepair cases stand and fall, as far as I'm concerned. Good records, you've got a good chance of escaping liability. Bad records, it's an uphill battle. So it's important to note essentially what is going on. Any failed attempts at access need to be noted. Letters ideally should be sent to the tenant after access hasn't been granted to say, we went round your house last week, you didn't grant access. And then that way, at least you've got some correspondence there that shows that you tried. Final tip there is prioritise the most urgent issues. Of course, lots of you will have limited staff now. Perhaps some of your colleagues have been furloughed. Your capacity to undertake all of this might be limited. So prioritise what's urgent is pretty much all you can do. And then the next 3 slides, I've essentially divided in thirds. So some tips in terms of before the job, some tips on going to the job, and some tips on the job. And again, this is just a quick one for all the surveyors out there. You probably get all of this already. It's hopefully might give you 1 or 2 ideas that maybe you haven't thought of. Some of it will sound patronising because it's pretty common sense, and some of it's just drawn from the guidance. So I've put it all together just to sort of provide a framework for you in terms of how to practically deal with this stuff during COVID-19. So the first thing is plan ahead. Ideally, you want to be doing risk assessments and questionnaires. So that will be a form asking the tenant to declare any issues that they have, whether there any concerns that they have. They might say, yes, we have symptoms. They might say, no, we're symptom-free, etc. And that should determine what steps you take after that. I would encourage every landlord to be doing these routinely, especially given the issues and what's potentially at stake. Now, obviously, it's difficult, isn't it? The tenant phones up for a repair. It's more admin. You've got to complete a questionnaire. It's draining. It takes up resources. So what I've put here is perhaps it can be done over the phone because you don't have the time, particularly in an urgent repair, to send the questionnaire for the tenant to fill out for them to return it to you. That's even if they bother to fill it out. Just do risk assessments over the phone, essentially. I think keep records of what you're told, and that I think would be a good start. You've got photos from tenant there, so get the tenant just to ping you a couple of photos from their smartphone, just so that you can sort of see what's going on. It might be a hard to reach place. It's just to kind of give you a visualization of what's happening so that you can plan ahead. We don't really have that now. Tenant phones up, says there's a problem, someone goes round. Maybe if some photos were taken, that would really help to sort of plan the job and understand what's needed there, so that you can be efficient and so that you can minimise any transmission issues. Equipment parts. So again, it follows on really from the point about photos. Try and get your parts ordered and your equipment ready for the job, because I think we've all seen it, haven't we? And it's a common bed bug, I think, a hate of tenants is the operative goes round, takes a look around and says, oh, you've got to order a part. I'll come back in 2 weeks. If you've got obviously the parts ready, or perhaps a range of parts to choose from, then that will obviously speed up the process. No sudden appearances. So by that I mean it probably isn't a good idea to sort of cold call for repairs. By that I mean, you're in the area, you tried to get access last week, but weren't successful, and you think, oh, let's go around to Mrs. Smith, see if she's in, and we'll sort out that ignition coil on the boiler. That's advised against because of it's debatable whether that's appropriate in normal situations, but certainly now that's something that I think landlords should avoid. And then lastly, in terms of planning ahead, postpone by mutual agreement. So if the tenant says, yep, I'm happy for you to do this repair in 4 weeks' time, I've reported it to you, but I'm happy to wait, and the landlord says, yep, that's something we can wait, then by all means you can do that. Keep record though, because you don't want the tenant saying I reported it and then the landlord did nothing for ages. You want a note there to say that everyone's agreed and are happy that this can be done at a later date. So that's planning ahead. In terms of going to the job, so good idea, and don't forget guys, this isn't just something I've invented. Maybe one or two I've chipped in there of my own back, but a lot of these are from the guidance as well. So do bear that in mind. So when you're actually going to the job, give the tenant a call, I think is a good idea, just to let them know you're coming and that you're going to be there, you know, in half an hour, 15 minutes, whatever. That'll obviously give them time to take any steps they want to take, wipe surfaces down, get their masks on, whatever it may be. Avoid public transport and car share. I mean, this is part of the guidance, and I know won't apply to most surveyors or landlords. I don't imagine any of you travel to residents' properties by public transport, but of course, if you do, if you find yourself doing so, try and avoid it. Car share is a big sort of alternative suggested in the guidance that has been issued. Keep vehicles clean, so repair vans, your mode of transport, that should be sort of cleaned and sanitised, and it might be a good idea to sort of start keeping records of that, because if something does happen or there's an infection or whatever, you'd be able to say, look, this is our schedule, we cleaned the van, you know, yesterday or whatever it may be. So a periodic sort of vehicle clean is a good idea. Going to properties in groups, in designated groups or bubbles, as Boris would like to call it, I think that's a good idea, or just keep it to one person. And then also areas. It'd be a good idea for groups to do certain areas to avoid, obviously, sort of cross-contamination or the risk of cross-contamination. And I think that's probably common sense. I imagine a lot of you already have your repairs service kind of set up that way, that certain people, certain groups do certain areas, just to be more efficient and more cost effective. And then finally, on the job, again, this is where it gets a bit common sense. You know, we're bombarded with all this stuff on the news and guidance is just everywhere around us. On the job, it'd be advisable to obviously wear masks, have wipes, hand wash, hand sanitizer, all of that. And again, this goes back to the whole negligence issue. If you don't have these basic sort of common sense things in place, and then, you know, there's a transmission or something, if the tenant then says, well, you know, this operative came round, he wasn't wearing a mask, he wasn't wearing gloves, I didn't see him wash his hands or use his own hand wash, if the tenant's a bit funny about the operative using their bathroom, then you can see there what the risk is, and how open you might be to sort of accusations of negligence. So even if a tenant says, don't worry, don't wear a mask, don't wear any gloves, I'd still err on the side of caution and do it, basically. Second on the list there is social distance. I mean, again, that's self-explanatory. Ask the tenant to stay in the living room whilst you work in the kitchen, or in the kitchen whilst you work in the living room. Sometimes the tenant could leave, potentially, if they trust their operative. Say, you know, the keys are under the doormat, or collect the keys here, and you can have, you know, access by yourself. Ventilation, doors and windows open. So again, this is in the guidance. Whilst the operative's in the house, just get everything open, ventilate everything. Take your own waste. Don't use the tenant's home to dispose of stuff. Take it all with you in a bag. Remember that it's not just about protecting the tenant. That says client, but it should say tenant. You know, you've got to protect yourself as well, because sometimes we forget that, you know, landlords are important too. It's not just about the tenant and catering to their needs and making sure they're happy. you've got to be happy yourself, because you're just as much at risk of transmission as a tenant is. You've got back-to-back working there. I think that's actually being suggested as a general resolution in society to social distancing. So I think I'm expecting Boris to announce that we can all go to pubs, but try and sort of stay back-to-back if we can. Avoid tool/equipment sharing. Apologies for the typo there. So operatives ideally should have their own tools. Might not be practical, especially if there are expensive tools and only one going around for everyone. But if it is something you can control, then by all means do. And then finally, be quick. Goes without saying. Get in there, get the job done, get the hell out of there. We're almost on our hour. Unless someone intervenes, I'm going to carry on for the next 5 minutes because I'm nearly at the end. In terms of getting new disrepair claims, there's essentially 4 steps. Step 1 is you get your LBA or your letter before action, and these will come from these horrible firms that are trying to sue us all the time. You'll all know that you've got 20 days to respond on there. However, because of COVID-19, I think it would be reasonable to respond later than that. So if you are getting any new claims and you need more time because either you haven't got the staff or your office is closed or whatever, do ask for more. Those should be granted. Disclosure, again, that's normally step 2. The tenant's lawyers often ask you to send the housing file. That's going to be very difficult at the moment, isn't it? Especially if we haven't got any access to our offices. Some of us are still getting to grips with paperless working, etc. Again, extension of time is completely justified in my view, so don't be scared to ask for those. Step 3 is the inspection. So that's when, following one of these awful letters, you go and look at the property for yourself. So of course, for that step, you maintain the safeguards and all of the issues we've just discussed about repairs during this pandemic. And then step 4 is your response to the claim. So that's your eventual letter going back to the tenant's lawyers, which says either, go away, your claim is without merit. Wanted to say something else there, but I stuck to without merit. Or you will say, look, hands up, we're going to sort something out here and we're going to do the right thing. So just remember those steps, and that, in a time like this, you should be able to get some leeway in terms of responses. And then finally, again, unless I'm kicked off because of time, I just wanted to share some experiences of cases that we've actually advised on in the last 2 months. The first one was the classic, landlord wants to do the repair, not now, I'm shielding. And the landlord on that particular case has got a court order which says he's got to do the repairs by the 1st of August, for example. So how have we resolved that one? Well, we've essentially made a record of it so that when it comes to going back to court and explaining to the judge that, sorry, judge, we couldn't do the repairs by the 1st of August, we've got a note there and we've got correspondence from the tenant which says I am shielding. So that should not put us in breach of the court order. Next one on there is go away, I'm self-isolating. And that's been a typical response from some tenants over the last 2 months. Of course, we don't know if they are genuinely self-isolating or they can't be bothered or what's going on. So how do we sort that issue out? Self-isolation, I think, is the maximum 14 days. So from the moment they say, I'm self-isolating, you diarise 14 days, and then you go back to them in 14 days and you say, right, you've finished your self-isolation, we want to get the repairs done now. Excuse me. The third one we had was really interesting, actually, because a tenant's door got broken down by police. There was an antisocial behaviour issue, and they had to get access. But to cut a long story short, we had a house with a front door ajar, and the tenant inside had COVID-19 symptoms. So of course the landlord comes to Clarke Willmott and says, look, what do we do? We're worried about members of the public potentially entering in uninvited. You know, can we get done for that, basically? How do we do the repairs when the tenant inside has got COVID-19? So it threw up some interesting questions. So the way we dealt with that one was, first of all, don't worry about random members of the public going into the property, because they should be doing that. That's burglary or trespass. And plus there's a stay-at-home order, so they shouldn't be going in anyone's house anyway. But in terms of getting the door done, what we advise the landlord to do is to engage a contractor, tell the contractor that the tenant has got COVID-19, and instruct the contractor to go on the basis that this is someone who has got COVID-19. Because of course they just had symptoms and there was no test. There was no way of knowing that they actually had COVID-19. So my advice was to take the belt and braces approach, treat them as COVID-19, tell the contractor that they have it, and then it's down to the contractor to deal with. I also advise the landlord that the contractor might be liable to charge more because you know, that's fair enough. They're taking a bigger risk and they might be more expensive than normal, but at least you'll get the door done and you'll avoid any problems. And then just the last experience I had is one or two of you on this webinar might recognise this one actually. We've got a disrepair claim in alleging all sorts of awful things at the property. Of course, we're happy to do them. We've agreed what we're going to do, but the tenant's not playing ball. So the way to resolve that one is we've sent a letter before action for an injunction, basically. So we're saying final warning to the tenant: if you don't let us in, we're going for an injunction. And I guess the bottom line from that, and for you guys to remember, is that injunctions are still available for you. If you're having difficulties getting access, you can still get in. The courts are still processing injunctions. We're doing loads of them for gas, for antisocial behaviour. I personally haven't had any access ones yet, but it looks like this one might turn into one too. So that's it. I hope you found some of these tips useful. Again, sorry if some of them were a bit obvious and a bit sensible. Sorry, I hope you found some of them sensible and hadn't thought of them. And it's only left to say good luck and stay safe. Thank you very much for tuning in. If you've got any questions, you get in touch with us either via this chat or just give us a little email at your own leisure. Our email addresses are displayed now. Our phone number's there as well. If you'd like to pick up the phone and discuss a scenario, please feel free. Thank you.
Danny?
Yes.
You do actually have one question from, I think it was Natasha, asking if PPE is not available, what would you advise?
Okay, so a participant has asked what happens if there's no PPE available. Well, what can I say? It's going to be difficult, isn't it, to maintain appropriate safeguards. I mean, I'd be interested to hear whether the PPE is not available because it's an internal issue or whether it's an expenditure issue. But certainly, I wouldn't be attending a repair without PPE, especially now. It's a belt and braces approach, I appreciate, and it's you know, it's annoying, but I think it needs to be found somewhere, and if it's not found, then potentially you're not taking the correct safeguards, and that could, in theory, prolong sort of the defect, if you like. I'm not sure whether the landlord will be able to say, well, you know, we couldn't do this repair within a reasonable period of time because we couldn't find any PPE. So I hope that answers it, but I'm afraid it's probably not going to help you, I'm afraid. I don't know if Muzz will agree. Yep.
Hello. I agree. I think it's part of the risk management process, and in order to carry out the works, you will need to have factored in appropriate risk management. Therefore, some steps will need to be taken. I mean, the situation will vary because in some instances, if you've taken the appropriate checks in place already, for example, asked the right questions and so on, then it may not be necessary for that particular property, but at some point it will be. So I think the risk assessment and providing that equipment is important and will potentially allow you to deal with more properties rather than have a huge build-up when all of this comes to an end. Are there any more questions? I'm just looking through now. There don't appear to be any more questions, so I'm just going to wait a few minutes, and then if there are no more questions, we may bring this to an end. The one thing I will emphasize again that I have mentioned is keeping records. That, I think, will be the best way of actually defeating some of these claims that will come forward. I can't emphasize that enough. So from Danny and myself, thank you for attending. I hope it was informative, and we hope to see you soon on the next one. Goodbye and take care. Bye.